We know that digital health law is going to play a key role in the digital health revolution. But what does digital health law mean? Digital health law has four main branches. The first branch is substantive law. This is when we look at a range of different fields of law, different areas of law, and we question how they relate to the field of digital health. So to give some examples, this can include an assessment of administrative law, constitutional law, contracts, evidence, torts, property, international law, medical law, intellectual property, and a range of other areas of law, and assessing those areas in the context of digital health. The areas of law that we tend to hear the most about are privacy and cybersecurity, but there are a range of other areas of law that are really fascinating that relate to digital health. And as time moves on, we're going to be exploring those many different fields of substantive law. So substantive law is really looking at an assessment of what the law is. And we're looking at a range of legislation, cases, and other rules and regulations that help us understand what the law says. Once legislation is passed through Parliament and becomes law, we then see the building of consensus around what the law actually means. So you'll see industry bodies putting together documents to describe what the law says you can and cannot do. You will see lawyers putting together information guides for consumers, for the public, to help them understand what the law says, and that is how we then behave within the realms of that interpretation or analysis that is provided to us. However, at times, the meaning of the law itself is brought into question. And then there is a whole assessment of what the words within the legislation actually mean. So when you're looking at digital health law from the lens of interpretation, you're assessing with a fine-tooth comb legislation, and you are asking yourself whether those words are potentially ambiguous and open to interpretation in the future. Putting a question mark over them, maybe you are hypothesizing about whether those words are going to be subject to an interpretation review at some point. So how do we go about this process of interpretation? Well, this is a specialty in law. Statutory interpretation is a very complex area of law that you must be an expert in order to help people understand the field. I think it's really important to be across this area of interpretation and legal methodologies, especially as we move towards a future world where artificial intelligence may be helping to actually write and interpret our laws. So we need to really be across those interpretive models and methodologies at this advanced level, and make sure that those who are creating these technologies that are going to automate law have an understanding of those disciplines as well. Okay, so another branch of digital health law is policy, lawmaking, and legal process. And this is when we unpack and try and understand policy decisions in the field of digital health, lawmaking, how it actually happens, what the procedures are in lawmaking, and the processes that are followed in order to produce those laws and policies. So here we analyze in a lot of depth the specific processes that lawmakers go through, and not only those within the legislative arm of government, but in other fields as well. The Legal Process School articulated 5 different areas of legal process. One is legislative analysis, case law analysis or judicial analysis. We then have administrative analysis, statutory interpretation, and private ordering. So those are the domains in which we are analysing legal process, and really looking at the types of evidence that these different bodies or parties utilise in order to justify their decisions to produce laws and policies. The next branch is the nature of law, and this is when we look at what the law is and what is its place in society. How is it going to serve us as we move forward in this field of digital health? So here we have philosophical assessments, ethical assessments, and theoretical assessments of the law as it pertains to digital health. So as you can see, digital health is a huge field. I'm describing this today because I really hope to encourage law schools to start, if they're not already doing so, bringing digital health into their curriculum. It's essential that we're talking about modern day issues, that we're teaching future lawyers about technology and the issues that are going to impact humanity as they progress through their careers. So I would love to see law schools incorporating topics on digital health law. And if law schools are not going to do it, or even if they do, what about tech schools? What about medical schools? Let's teach our students about these important topics. In the past, I've found that my students who are tech students, marketing students, are really fascinated by law, and often it's the students who are not studying their law degrees who are really interested in the subject discipline, and they will often say to me, I'm really interested in law, I want to learn more about it, I want to know more about it. And let's give them that opportunity to learn more about this important field. I hope to see this discussed more and more in law programs, in medical schools, in IT programs, across the board. There needs to be some discussion of a critical piece in the digital health revolution, and that is law. That is law, philosophy, ethics, and it's all together in that discipline of digital health law. Thank you very much for listening. I hope you have a good week, and I'll chat to you next time on the Voice of Law podcast.